Good morning to everybody. Um, so what I'd like to do is to introduce Greg Oropeza I know a lot of you know Greg, and have worked with Greg. Some of you may not, especially those of you in the upper keys, you may not have had the opportunity to work with Greg. I've known him for a really long time. And we've done a lot of business together. And he was very gracious when I called him and I said, I need help. Can you spend some time with us and go through um, some title issues, kind of walk us through 9C title evidence, item 18, so that so you are all have a better understanding so that you can articulate what those items in the contract, you can articulate what they mean and any possible impact they might have on your buyer or your seller. Then I asked him about assignability because there's some questions that I've encountered here. So we're going to talk a little bit about that. And then yesterday he called me because he wants to talk about FinCEN. And I said, I don't even know how many people are aware that there is a FinCEN provision in the contract, which really hadn't applied to us up till now. So with that, Greg, I'm going to turn this whole thing over to you.
Well, thank you, Ruth. Thanks for asking me. Always happy to do it, and nice to see all of you on Zoom land. It looks like I probably know or have worked with about half of you. I'm gonna go in. I'm gonna do assignability first, just because it's kind of shorter. And so I've broken it up into three parts. We've got assignability, and then we'll go through the title review in paragraph 9 and 18, and we've got an example commitment and survey. And then we'll go through FinCEN, which is a new requirement that starts March 1st. So it's coming up and it's going to impact all of you. And I think a lot of it's just going to be educational for educating buyers and sellers. I'm going to go ahead and share my screen. So Ruth, does that show up?
Yes.
All right. So
Yep.
we'll jump right into assignability. And feel assignability, it's short. So this is the assignment clause in the contract. I'll tell you one of the most common questions I get is, do you need an addendum to assign the contract? Technically, the answer is no. You don't need an addendum signed by buyer and seller. You do need an assignment signed by the seller. So the ability, if the seller in the contract has the right to assign, that's a unilateral right, meaning they can do it without the seller's consent. Now we know the lenders like to make up some rules sometimes, so a lot of times you have to comply with what the lender wants if they want an addendum. But if you're not in that situation, for example, if it's a cash transaction, you can do a simple assignment. And you definitely want to do that. You want the file to match. So whoever closed, whatever name they closed in, you want your file to match that. So you've got privity of contract the entire way. Ruth, were there any specific questions on assignment? Because that's really all I had, but if I'm happy to answer any questions the group may have.
Most part, we've always taken the position when we're writing a contract that we are going to choose may assign but not be released from liability under the contract, um, so that the buyer is able to, let's say, change over to an LLC, maybe bring in a husband or a wife that have that flexibility and not be released. So that has always been at least my preference. Could you talk a little bit about that, which is the better way to go when you're, because I have a couple agents who are saying no, they feel it should be may not assign the contract. So could you talk a little bit about that?
Yes. So my personal preference is also may assign, um, but not released. And that way we keep the original buyer on the hook. Um, if you had may not assign, technically that would prevent a buyer from purchasing in a trust or an LLC or a corporation if they wanted to. in that situation, you would need an addendum. Um, but we typically, when we're representing a buyer or a seller, would advise to use the assigned but may not be released. The important part of that is that whoever you went under contract with is still obligated to make sure it closes. You know, I can't actually remember one that I've seen where it says may assign but be released. Because then that buyer is completely out of the situation and you don't even know who you're dealing with. But those are my thoughts on that.
I have a question.
Sure. Hi, Jeff.
So if you said you don't need a contract amendment signed by the seller and the buyer, but you do need an assignment document, well, what document would a selling agent use to effectuate a assignment?
So you could ask, for example, the closing agent who's handling it if they're willing to give you a simple assignment. Florida Realtors does have an assignment. I believe that assignment has initials for the seller, though. But it's technically not required from a legal standpoint. So you can use the Florida Realtor form. If not, you would need some sort of simple custom form. A worst case scenario, I think you could put it in a blank addendum and just have the buyer sign it as well as kind of, a quick solution to that situation if you needed it. The
Gotcha.
only thing that makes it effective is that the buyer has signed it.
Okay, thank you.
Hey Greg, it's Natalie. I just have a quick question for the assignability because a lot of people they will put it, say it's like a husband and wife's name if they're going to put it into a rental and put it into an LLC. What's the time frame that you guys would need? Because I know a lot of times like the closing agent or attorney will be able to set up that LLC for them. What's a good like lead time for you guys if they tried to set up an LLC?
Right. So Natalie, assuming it's kind of it's a cash transaction,
Right.
we can set them up pretty quickly. We use a company called Capital Connection, which is an expediting company in Tallahassee, and usually we can get the LLC live in 48 hours.
Okay.
We'd prefer not to do it that quickly, but general rule of thumb, if it's a 30-day closing, 15 days out. Because the other part of that is we have to prepare the documents, or the closing agent has to prepare the documents. So typically they're preparing those about a week out. And so if the buyer flips into an LLC a couple days before closing, everything gets redone, which is not a problem. But, and I actually have a note to mention this in FinCEN, and I'll mention it now, is with FinCEN now, it's probably more important to have the LLCs created earlier in the process because FinCEN triggers when there's an LLC. So if you have a cash transaction and it's husband and wife, there's no FinCEN. Cash transaction with an LLC, now you have FinCEN. So there's an extra layer of documentation that has to be done, including obtaining EIN numbers from the IRS, which can be done very quickly. We can get an EIN same day. But kind of the days of, hey, right before the closing, we want an LLC are going to go away a little bit because of FinCEN. And
Okay.
I'm going to touch on that a little bit when we get to FinCEN. So, I'd say, Natalie, worst case, if you tell your buyers, look, we need to know at least a week out.
Okay.
Hey, Greg, this is
Thanks,
Josh
Greg.
Martin.
Hi, Josh.
Greg, yeah. I know you talked about separating out financing. When there's financing, you shouldn't be changing the LLC after closing, right? Can't that screw up the loan with a due on sale?
Yeah, so good question. So get that question a lot. So, and frankly, a lot of lenders say, oh, just transfer it in the LLC after closing. So in the standard loan documents, Fannie Mae, Freddie Mac, even the non-Fannie Freddie, there's a prohibition on transferring the interest in the property. And that transfer could be from husband and wife to an LLC. That is a trigger of the due on sale clause. The other consideration is when you do that, the Florida Department of Revenue requires doc stamps to be paid on the deed. And they calculate the doc stamps based on the mortgage. So when you have a closing and after the closing, the buyer is transferred to an LLC, you got two issues. One is the lender technically doesn't allow it. And two is the Florida Department of Revenue will require documentary stamp tax.
Okay.
All right, I'm going to go to paragraph 9. So this isn't paragraph, the title evidence is in paragraph 9. This is not title evidence here, but I'm going to touch on something because I see it a lot. So closing costs, and if you can see where my mouse is, you see sellers closing services, and then we've got buyers closing services. And I think this is more something that you all see probably Marathon North. We're starting to see it a little more in the lower keys. Situation where you have a party who picks the title agent, let's say it's the buyer, and they pick their Miami or Fort Lauderdale closing company. And that Miami or Fort Lauderdale closing company wants to charge the seller a fee to prepare the closing documents. These three words, seller closing services or buyer's closing services, that's where that closing agent is going to have the right to do that. Now, my personal opinion is they're closing a transaction in Monroe County and it should follow Monroe County custom, which generally we don't see these fees that the South Florida closing agents charge. We're seeing fees as much as $1,250 to prepare seller documents. So whenever I can, I would just suggest, if you're in a situation where the buyer is paying title and you have the seller, that's fantastic. The seller's not going to have to pay for it. But, it might be worth just asking the question, hey, how much is the buyer's closing agent going to charge the seller? And if that amount is too much, you can limit that in the special terms. We're running into this more where once the closing company from South Florida gets a hold of it, they've kind of got the seller in a position where they can't do much. It's not fair, in my opinion. I would possibly go as far as it's borderline an ethical issue as a lawyer, anyways. But it's a situation we see, and I think it's very easily prevented if you just add it in the contract. So, you could put, for example, seller shall not incur more than $500 to closing agent. Or maybe you don't want them to incur anything, and maybe it's just, buyer shall pay all closing costs to closing agent kind of situation. So just something to keep your eye on. I'll give you an example. We have a closing in, I'm representing a seller in Duck Key right now. And the closing company's in Miami, and they reached out and said, hey, have you ordered the estoppel? I said, well, normally the closing agent orders the estoppel because it's for title. And they said, well, we charge $150 to order the estoppel on top of the estoppel fee. So ordering an estoppel is a simple email, but they want to charge the seller $150. So we said, we'll order the estoppel, no problem. But you just got to pay attention because outside of Monroe County, the fees are a little bit different.
Hey, Greg.
Okay.
Sorry, real
Yep.
quick. It's Natalie. I have a question. So even if like on that service, seller closing services, like if I have that situation, I did not that long ago where the buyer's agent used someone out of Miami that I just wasn't familiar with, recommended using one of our, a local person here. And can they still charge when they have like when the seller has decided to be represented by somebody else?
No,
Okay.
no, in that situation, they cannot.
Okay. Thank you.
Yeah, because in that situation, they're not preparing the closing documents.
Thanks, Greg.
Yep. Okay, so title evidence. I think probably title evidence and title insurance is probably something you don't run into too often until it becomes an issue. So it's good to have a good understanding of it and try to prevent some of the issues. So the default for title evidence is in 155. And what that provides is a 15 days prior to the closing, or 5 if 8A is checked. Now, 5 is short because if there's an issue with title, you're going to go past the closing date. But the buyer has to be provided a copy of the title commitment. So this essentially functions as a contingency, and I've seen people, at least in one instance, where the buyer did not receive the title commitment within the timeframes that were set forth herein, and the buyer was able to extend the closing because they didn't meet they weren't provided with the contingency. Now, the interesting thing here is it's kind of a question is who's responsible for providing this title commitment. I would say it's the closing agent who has the obligation. So once the closing agent takes on the closing, it's their obligation. But if they don't provide it, it's not a situation where the seller could say, well, that wasn't my responsibility. The buyer doesn't get to make that argument for the contingency. So, a lot of times what we're seeing with the real estate agents is on their checklist is asking for the evidence of title. So it's just something that in your critical dates, make sure you have the evidence of title, get a copy of the title commitment from the closing agent, throw it in your file. For example, what we do in our practice is we save the email. So when we send the email with the title commitment to the buyer, we then go and drag and drop that email into our title folder in respective closing, so that if it ever came up, we can prove when that was sent. And so what they're required to do is provide the title commitment. The contract also says to provide a copy of the title exceptions, which are on the commitment. The easiest way for that to occur is with the title commitment to be hyperlinked. Sometimes these document packages are hundreds of pages long. And I'll tell you that the standard, most time they're not getting the exceptions. It's just the commitment, unless there's an attorney involved.
So question on that.
Sure.
If the closing agent sends the title commitment to the, let's say the seller's paying title, so the seller's controlling the closing. They send the title commitment to the buyer's closing agent, and they don't attach the exceptions and instruments or whatever you call that. Does the time clock start if those are not attached?
It's a great question. So there was actually litigation on that situation a couple of years ago, I believe out of West Palm, and the court said that the time frame restarts once the exceptions are provided. So the 5 days would re-trigger.
So the time clock doesn't start until the exceptions have also been sent.
So, Sam, the court wasn't that clear on that. What they said was that the buyer came back, and I might not have the days exactly correct. Let's just say the buyer came back 2 days after getting the commitment and asked for the exceptions. The court said once the exceptions were provided, the 5 days started again.
So
they
let me
didn't specifically say that the time frame didn't start. They just stated once the buyer had requested the exceptions, it was a restart. Now, if you wanted to be absolutely certain that the time frame starts, those exceptions should be hyperlinked on the commitment.
So if the closing agent sent it without the exceptions, and then let's say the buyer's side didn't respond in time, now the 5 days from that original send has passed, but then on day 6 they realize they don't have the exceptions. They looked them up themselves, and then they realized they're a problem. Can how would that rule to
Yeah.
is there's an argument there that 5 days didn't actually start, I think. No?
Yeah, there definitely is. I think you'd have to take the argument that the buyer would have had to respond within the 5 days requesting the exceptions to make that clear.
Got it.
But yeah, I mean, there's definitely, I mean, you're pointing out a couple of issues that could come up.
Greg,
Mhm.
if there was issues, wouldn't the title company be communicating with everybody to let them know what those exceptions are?
Yeah, so Diana, it kind of depends on probably the title company. So I can only speak from my personal experience and what we do. Um, when I get a commitment, I review it. If there's something that's not normal, so let's say there's an easement for the neighbor to have their house partly on the property. We'll actually separate that easement and send it to the buyer so that it's forefront, so that there's no, because if a buyer who doesn't have an attorney is not going to be most likely educated enough to know what they're looking through. So we kind of separate that out so there's evidence that it was sent to them. And then, of course, if they have questions, we'll try to answer that. But yes, I think that the closing agent should be at least identifying, hey, this is something that may not be run of the mill for, this area type situation.
Right. I would just assume that that would be all taken care of because you're looking at the survey and seeing the property lines and everything. So it wouldn't be just a mute point that everybody would just look at and forget about.
In theory, that's correct, but I'm sure there are situations where that doesn't occur. Okay, so this is.
Can I just say one thing before you move on from
Yeah, of
9C?
course.
Okay. Remember, everybody, when you're using the Monroe County Local Rider, okay, it amends 9C, okay, with regard to the seller providing prior title policy, because the way 9C is written, if it's not, as you say, not delivered within 5 days if the seller's in possession of the effective date, the buyer can get out of the contract. The Monroe County Rider amends that, so it will not be considered a breach of contract by the seller and shall not constitute grounds for cancellation of the contract. So you have to always look at Monroe County Local Rider, item 3.
I gotta look at that. Let me see.
Yeah, that's a good point.
Okay. And it applies to the survey as well, which is later on. So.
Okay, so we're just kind of going down 9 paragraph. We started with the closing costs and then evidence, and then this is, buyer or seller pick. The reason I put this in here, because here's that closing services again. This is a relatively recent change within, I believe this went into effect in October of 24. And they define closing services, which if you were to go to the statute, talks about what services are considered closing services. For example, on a seller side, it would be preparation of the deed, closing affidavit, those type of things. So not much to talk about on this one unless there's questions, but I touched on these kind of tips, I'll call it, earlier when we talked about it, just kind of having that conversation up front on what those costs may be for your client if they're not paying. But are there any questions on, these options? Check the box. I know some people ask about the Miami-Dade rider or Miami-Dade provision sometimes.
I think that if you could explain the Miami-Dade provision quickly, that might be helpful.
Yeah, so we actually, the committee tried to remove the Miami-Dade provision last year, and there was a lot of pushback from Miami-Dade. So Miami-Dade, the way that you think about it is it's buyer pick, buyer pay, but then the seller has to pay up to $200 for the title commitment, and then they pay for the lien search, tax and lien search. So tax and lien search, depending on the service provider, you can estimate on average about another $150. But the general premise of Miami-Dade is buyer pick, buyer pay. Okay. So we've kind of gone through paragraph 9 and we get the title commitment. And then the question is, let's say there's something, what happens after the commitment? And here's where we get into paragraph 18, which are the title standards for examining the commitment. So once the commitment is provided, then the buyer has 5 days to review. and make any objections to the title. It's very rare that we see objections to title, fortunately, but it does occur sometimes. Um, something that may be an objection is an easement, survey issues where you have encroachments, for example. And in the contract, there's automatic provisions that the buyer can invoke to require the seller to cure. So the initial cure period is 30 days. So the way I calculate the 30 days is 30 days from when that notice is provided. And so during that 30 days, the seller has to make good faith efforts to cure that. So of course, the question is, what is a good faith effort? The way I explain it, it's any, they've got to reach out to their neighbor if there's an encroachment. They can't just say, well, he's never going to give me an easement. Is it having to pay for an easement? No. Is it having to file a lawsuit? No, I don't think it forces you to do that. But they've got to make an attempt to resolve whatever the issue is. Sometimes it may be a deed restriction from a city or a county, for example, that may have been issued in error, so they can reach out and try to have that released. But it kind of depends on a case-by-case basis. And in the event they are not able to cure it within 30 days, then the buyer can extend for up to an additional 120 days. So you've got a possibility where a buyer can hold up a seller for 150 days. The 120 extension is rare. At that time, most people are just moving on. But I have seen it occur. So it's something that the sellers need to be cognizant of, because at some point, there's probably a cost benefit analysis of trying to resolve it with some financial consideration, opposed to trying to hold the contract up for 100 and up to 150 days.
Greg, this is Alina Davis. Have you had any experience with a restrictive covenant that is placed on a piece of property becoming an issue?
Depends on the restrictive covenant. Do you have one in particular? Or
Well, the one that Isla Mirada is using, and they say it's for FEMA, but they're trying to use it for an upstairs of a garage that is storage. Says that with 24-hour notice, they can come and inspect.
I have not seen that one. I would say that would fall under marketability of title, so a buyer would have the right to object to that.
Mm-hmm.
The one I have seen in Isla Mirada is, just saw one recently they built a detached garage, and Isla Mirada required them to record a restrictive covenant stating that it wouldn't be used for residential habitable space. The county calls them the lockout deed restrictions.
All right.
But I haven't seen that 24-hour language in there.
Yeah. It's the one that Isla Mirada uses, and it does have a 24-hour
Okay.
inspection period.
I'm personally of the opinion I'd like to give the government less inspection right, not more.
Right.
I have a question.
Thank you.
Yeah, I have a question about the cure period. So, since I've been a manager in the Upper Keys for the last 6 years, probably several times we've had title issues that had caused us to uh, go into this cure period. My opinion has always been that I don't need a written contract extension, because the cure period covers the extension. And I'm just wondering if I'm giving good advice or bad advice.
No, I completely agree with you.
Okay.
Yep. Again, that sometimes is changed by lender requirements where they want
Right.
addendums no matter what, but absent a lender, I agree there's not an addendum needed because the contract already provides for the extension.
Okay. Thank you.
But Greg, during that period, can a buyer walk at any time?
Once the initial 30 days is invoked, they have to give the seller the ability to try to cure.
Gotcha.
If
Thank you.
if they're unable to cure within the 30 days, then the buyer can terminate.
And then they just get their deposit and everything
Yeah,
back.
they're released and they get the deposit back.
Super. Thank
Yeah.
you.
And not to get into kind of the nitty-gritty on the legal side, but of course you can get into situations where you're debating whether something is cured or not. So we put in here an example of a title commitment, and we'll just go through quickly. This is page 1. This just kind of sets out the parties, the buyer, the seller, the legal description, and the price. This particular example is a cash transaction. So if there was a loan, there'd be a lender here. And this is what we call Schedule B1. So Schedule B1 in a title commitment, that's kind of the roadmap to delivering clear title. And what that does is sets forth requirements that the title underwriter would require the closing agent to comply with to issue clear title. So your marketability of title and title cure issues can come up in 2 places. They can come up in either B1, where the seller may not be able to comply with the documentation, or B2. Now, you're probably thinking, well, how can they not comply with documentation in B1? So I'll give you an example that we're dealing with right now. It's a property on Eagle Avenue where the current owners have owned the property for 2 years, and the previous seller 2 weeks ago filed a deed on the property. The current owners were alerted to that, and we filed what's called a quiet title to extinguish or strip that deed. But if they were going to sell the property, in B1, there would be a requirement from a deed for that person who filed what's called a wild deed, because they were in the prior chain of title. And so absent compliance from that person, you'd have to file a lawsuit, and that's what we did. These people aren't under contract, or they're not selling the property. It was just a situation that came up. I'll tell you also that that individual who filed the deed, he had a warrant issued for filing a fraudulent deed, and I don't think he's been arrested yet, but we anticipate that he will. But that's just a situation where you may have a B1 requirement that is outside of the seller's direct control, and there's some sort of judicial intervention that may need to occur. B2, this is where the exceptions are. So we talked about earlier links for exceptions, or package of the exceptions. And this is where you would see them. So B2 is where if there's an easement on the property for access, it's going to be listed. The survey exception. So a lot of people ask questions about, when there's a loan, do I need a survey? And the lenders like to say, well, the closing agent's requiring the survey. The real answer is actually that what the lenders require are called what's an Alta 9 endorsement. And that's where the lenders want the survey exception removed. And if you see in item number 2C, this is what's called the general survey exception. And that's what the lender is asking to have removed. And the only way to remove that exception is with having a current survey, or a survey that can be reused, and an affidavit from the seller. So I think, especially in the lower keys where you're going to have marketability of title issues, it's with surveys. In Key West, in particular in Old Town, we have a lot of encroachments. Some are common, some are not, but that's where you're going to see it. So once the a general survey exception is removed, there would be a specific survey exception inserted based on the current survey. Now, this list of exceptions, for example, that are here right now, this is the Key West property. These are all standard. So these would not be things that somebody could object to. because anybody who purchases property is subject to these. So some of the things that are not title related matters are zoning ordinances. So, how high you can build your property or setbacks, licensing. So if you need a license to rent your property or operate a business, that's not title. Permits. Permits are not title. Permits have no impact on title at all. So you can close with open permits. It's not an exception on title. And then there's some administrative code from the state, which is the area of critical state concern. This one in particular is an historic district. So we have the City of Key West Historic Preservation District. I know, for example, in Islamorada, there's a historic district. So those are all items that are going to be on title, are going to be exceptions no matter what, and not objectionable.
Hey, Greg. I
Yeah.
recently had one that made me think when you said the permits, they're, not an exception on the title. Literally, I was asking a lender, and that was the exact verbiage that they use. Does it usually just come up with lender issues for having an open or expired permit with properties?
Not so much that we see it. It's
Okay.
purely when it's added in a special term.
Like in the local rider.
Yeah, seller to close, open or expired building permits, which, if I'm a buyer, completely understand you want them closed because there's lots of situations where you purchased the property and there was an open permit and you found out that the seller didn't do the work to code or they enclosed something downstairs.
Could I,
So
I'm going to
the
give you this
permits are
example.
not,
Go ahead.
yeah, the permits are not, they don't impact the lender either.
Okay.
The loan. They have no issue with lien priority on the loan.
Yeah, because it was just interesting. We're doing, and the buyer wanted to keep it open. There's spalling work that needs to be done, so it was just opened. Instead of repaying those fees essentially. But after going through it, the lender was like, as long as title doesn't do an exception, but it wasn't, and it was just got kind of a little bit convoluted, and we ended up closing it out anyway because he was worried about the lender not being able to provide the loan.
Yeah, so you might have had a different, another nuance too, is if there was ongoing work, then there would have been an open notice of commencement for the contractor, which is a title issue. Because notice
Okay,
of
yeah, I know that wasn't
commencement-
filed yet, I think. But yes,
Yeah.
that makes a lot of sense because those conversations did come up. So
Yeah.
it just happened. That's why fresh in my
Okay.
mind.
But well, in theory, yeah, normally it shouldn't be a lender issue.
Okay. All right. Thanks, Greg.
Yep.
Well, it's a demo permit. Just kidding.
Yeah. Yeah. Okay, so we also put in here an example of a survey. This survey is in Old Town Key West. Just use it because it has a really distinct encroachment. If you all can see where the mouse is circling, it's about 150 square feet of this building is outside of the property line. This doesn't really show the name, but this is on a lane. So this historic structure is outside on a lane. These folks want to sell the property eventually, but they came to us to help clean it up. So we're working on a quiet title to get a court order. And so what will happen with the court order is the property line will then move to go around the building based on the amount of time it's been there. So quiet titles are, you've heard me mention it a couple of times, are one of the main tools we use to clean up some title issues. If this was a survey that was part of a closing and the buyer did object to marketability of title, this is a pretty clear-cut example of where a buyer could use the title standards to object to marketability, and if the seller was not able to cure within 30 days, terminate. Any questions about surveys?
Yeah, Greg, I've heard different things. Is there a standard age for a survey that could not be used with an affidavit, even if there was nothing changed on the property?
Technically, no. So general rule of thumb, I personally have 20 years. So as long as it's within the last 20 years and there's no change. The reason I use 20 years, Josh, is just, it's just kind of, that's when the technical standards of the survey update a little bit. You know, when you get before that, the surveys aren't quite what they look like today.
Right.
But that is a closing agent to closing agent preference. That's my preference, is 20 years with no change. Now, if within that 20 years there's been a pool built, obviously they'd have to get a new survey.
Right.
Yeah. But if there's like an AC replaced in place or small components type situation, we generally do not make them get a new one.
Okay. Thanks.
Um, all right, so this is the last one on the title standards, and we talked about this a little bit, but this goes into what is not an exception that is objectionable. And so in the contract, we have already that these items, the A through F, the buyer cannot object to. These are items that they're agreeing to upfront, which are mostly zoning, taxes, unplatted utility easements. So for example, that utility line that's running over the front of the property to connect electric, you know, the electric companies have a built-in easement, even though it's not recorded. So those are items that they can't object to. Before we move into FinCEN, are there any other questions on title? Okay. FinCEN. So this is something that originally was set to be implemented October 1st of 2025. And the government came out a few weeks before that and said, hey, we don't have the forms yet. We're going to push this back to March 2026. And this is the idea behind this is an anti-money laundering, anti-terrorist funding, anti-drug cartel situation where the government is using real estate transactions to obtain information. And so what this applies to is a cash transaction that is closed and the buyer is in an entity, so an LLC or corporation or a trust. So if you have a buyer starting March 1st that closes in a LLC, corporation, or trust, or some variation of a company, there are other types of companies, the closing agent is required to report that sale to FinCEN. The reason why this is kind of new on the buyer side is closing agents, for example, have never had to ask the buyer in a cash transaction for their social security number, for their EIN number. And it's not just the entity that gets reported, it's anybody with a beneficial interest. So let's say you have an LLC with three members that are 33% each owners. All three of their names get reported to FinCEN. In a situation with a trust, the trustee gets reported, and potentially any beneficiaries that have control. And so it only applies to residential, 1 to 4 family. This in vacant land, which we found kind of comical because the government said that there may be an intent to build a house there one day, or mixed use that has residential. So the trigger is pretty simple. It's residential and an entity or trust. And so I've highlighted the TIN, which is tax ID number, because I think this is where you're going to initially see pushback from buyers. It's like, hey, I don't have to give you my social security number, especially where you have multiple members in an entity. You're going to be collecting all of that information. So going forward, you know, for your transactions that are occurring after March 1st, I would definitely be having that conversation with buyers if they want to close in the name of an entity or trust. It's absolutely no issue. It's just a little bit more documentation. And they're going to be asked some questions that they're going to need to provide. So the requirement to report this is within 30 days of the closing or the next calendar month. I will
So
tell you
Greg,
that from a transaction side, if the closing agent closes and doesn't get this information, they're probably never going to get the information, and the penalties run in the tens of thousands of dollars. The penalties are against the closing agents.
So it's the closing agent's obligation, not the buyer, to send that information.
Yes, it's the closing agent's obligation, but it's the buyer's obligation to provide the information to the closing agent.
right. So Greg, in the example of like a nonprofit, does the whole board have to do that?
So there are some exemptions, and nonprofit, I believe, is one of them. I didn't put the exemptions, but there are some exemptions.
Okay.
A not-for-profit 501c3 is one of the exemptions.
Okay.
Yeah, we're really only talking, for-profit purchasers.
Right.
And then we get into what is a beneficial owner. The general rule of thumb is beneficial owner is you own 25% or more of the entity, or you're, for example, a trustee or a primary beneficiary in the trust. But that's kind of been on FinCEN. So the closing software, so we all use software to help us with our closings. They just started rolling out the submission documentation this week. So I know, for example, our office, we've done 3 webinars this week so far. And we think we've got which service provider we're going to use. But that could change it changes from office to office. But the general rule of thumb is just the buyer, the owner of the entity or trust is going to need to provide their social security number and some information for the closing agent. Any questions about FinCEN?
Yeah, I have one, Greg. Are we going to have to do anything from a contractual basis to incorporate this change? Is there something there? I mean, I know we did with the Chinese and others, buying up property, we had that. Is there any idea that they're going to do some kind of a notice in the contract or something?
I think we have that coming, Ruth, but I'll double check
Yeah.
because I forget
Mhm.
what we talked about in January.
Okay.
I-
So
If
this
it's
is,
anything, it's going to be like the 1031 language where it just is a disclosure that they have to provide it. For
Mhm.
example, the 1031 language just says, if a buyer or seller want to do it, the other party has to cooperate.
Right.
It's going to be like that.
right. All right. But yeah, if you just let me know if we're going to be doing some sort of a notice.
Yeah.
So
Yeah.
this is, and this is any cash transaction, regardless of value, residential.
Yeah, any residential, regardless of value. This has been going on for quite a while in the Tri-Counties, Miami-Dade and Palm Beach and Broward through what's called a GTO, a geographic targeting order. And now basically FinCEN has just expanded that nationwide. They used Miami-Dade Broward as a test case for about the last 10 years.
Right.
That one had a limit because it had to be $300,000 or more,
Mhm.
which we don't have many closings below that anyways, but it's an expansion of what they've been doing.
And I would assume since they're expanding it, that it's been a successful program.
Possibly, I don't know. I know Miami, I think Miami, they were targeting mostly the Venezuelan purchases because Miami historically has had a lot of Venezuelan investment.
Greg, you said, is that $300,000 exemptions still in place with this? Because there are lots that sell for less than 300.
Yeah, good question. No, this is any amount. That the 300,000 went away.
Okay.
Yep. That's all I had, Ruth. Are there any other questions?
And that was great stuff.
I have a quick question. Legal descriptions,
Mhm.
okay? Um, it says on the property record card in red, not to be used on legal documents. Our direction to everybody is the legal description ends before the first OR. And we're pretty good at when we get offers from other agents to continue to have they have all the ORs. We're pretty good at dealing with that through counter offers and so on. Is there an impact to title insurance if it isn't corrected and we've got that whole thing in the contract, all the ORs?
From a title standpoint, no, because that legal description is not used for conveyance. So that's for identification purposes on the contract, but we can't use that for conveyance. So those ORs don't transfer over onto the title side.
I would assume best practice is to not have them appear on the contract.
It's much cleaner that way. If it's just the, plat book page, book and page, yes. Because a lot of those ORs are not necessarily, they could be probate orders, they could be quitclaim deeds. So they're not necessarily related to the legal description in the property. They're just instruments that were filed
Right.
that are tagged to the property. So they could be, for example, affidavits. So it is much cleaner to not use those.
Okay. Anybody, while we
By
still
the
have
way, I
Greg,
get that question from non-Caldwell agents when they're working with Caldwell agents, and I always tell them, it's perfectly fine to just use what they're suggesting.
yeah, we've been, pretty much focused on that for a long time.
Yeah, I think when you all first started, I would get the question a lot, and I was like, there's absolutely no problem with stopping it before the OR book and pages.
Okay, yeah. That's something that Tom Wright was always very serious about. So
Yeah.
we
I think his
adopted that
concern
practice.
and I know his concern because I talked to him about it, was that those, like I said earlier, those are documents, not necessarily legal descriptions. And so they're,
Mhm.
you could be incorporating something in the document that you don't want to.
Morning, Greg. It's Vic Musmano.
Hey, Vic.
Regarding assignability, I have some older sellers that are usually insistent about adding and/or assigns to the purchase contract for the buyer's names. It's redundant, correct? If the correct box is checked for assignability in the contract?
Yes. And I would say that whatever box is checked is what's going to control. So even if you put,
That was my second question.
John Smith and or assigns, you're still going to have to check a box, and that box is going to control.
Thanks.
Mhm.
Anybody else have any questions while we have Greg?
I just had a quick one about the FinCEN. If we have to provide this information, or the buyer has to provide the information, if they ask us what are they using the information for? Is it just documenting where the money's coming from, or is it further research is going on with this behind this?
So I think there's two answers to that, Annalise. Number one is, it's important that they understand it's a federal law, so they have to provide it. What is the federal government providing it for? What they tell us the reason it's for is to find or prevent money laundering that is used in various criminal activities. So their goal is to find money that's flowing into real estate transactions from criminal organizations. So as long as your buyer is not a criminal organization, they should have no problem providing it.
Okay, thank you.
Yep. To kind of give you an example of, if in Miami's heyday of cocaine cowboy era, for example, they were basically washing the money into real estate. And so this is that type of situation, but from more foreign investment. So they're trying to locate more foreign investment that's coming from criminal organizations.
Hey, Greg, it's Carolyn Fry with Mortgage Lending Solutions. I was lucky enough to pop on and be a sponge with the agents at Caldwell. In the spirit of helping save buyers money, on a survey, if you guys have a seller survey, I know you said up to 20 years old potentially, that can be used for the buyer's transaction. What if the seller doesn't have one? Is there a way to sort of get our hands on an old one if the current sellers are not good paper people? That's always a problem.
Yep. It depends. The only way to try to find one is through a public records request to the building department. So
Oh.
if there's been work done to the property, you could try to get a public records request in, and they're pretty quick to turn them around. The problem usually is that the survey that is submitted with the building permit is pre-work, and there's not an as-built after the fact survey. So the survey that you're going to get back from the public records is not going to show any work that they did pursuant to the permit. So you'd need an updated survey anyways.
Okay.
But for example, if they, did something minor, the survey might be able to be used. That's how a lot of people used to get elevation certificates. When Mary Wingate was there, she would just email them, but now it's more formal with the public records. But when you needed elevation certificates a bit more, the county public records was where to go.
Awesome. Thank you.
But otherwise, they're not recorded, they're not registered anywhere.
Usually I call Reese and if the majority of them they've done, so they'll have records of them.
Yeah, so I was going to say, so Reese is really good about providing copies. They're one of the few survey companies that will just give you a copy of one they've previously done. Most survey companies won't release them.
Anybody have anything else for Greg? Yes, no? Okay. Well, Greg, thank you so much for giving us your time today. This has been really informative. I really appreciate it. I think all the agents do, and we had a good group today. So thank you again so much. And you can expect that I'll call you again
No problem. Happy
and
to do
ask
it.
for help.
And I'll double check that FinCEN amendment on the contract, and I think we hit the hour right on the head.
We did.
10:59, baby.
Yeah, this was great, Greg. Thank you.
Anytime. And if you have any follow-up questions, anybody feel free to email me, give me a call. Always happy to help.
Thank you, Greg.
Thanks, Greg.
Thank you,
Have a
Greg.
nice day.
Thank you, Greg.
Bye-bye.
Thanks.
Thank you.
Greg, are you going to give me the slide deck?
I'll email it to you right now.
Great. Thanks so much.
You're welcome.
All right. Take care and thanks again.
Hi, guys.
Hello, this is Boris Ganya. I really appreciate your phone call. I can't get to the phone right now, so leave me a message and I'll get back to you as soon as possible. Have a great day.